Hello everyone, welcome to our third class lecture for business law at Columbia College. My name is Cassandra Jenneke and I'll be your instructor for this class. You should be seeing my screen share right now. So today what we're going to start talking about is crimes and torts. So last week what we started doing was building our foundational knowledge of the type of vocabulary that we're going to be using, and just a basic understanding of the law. We will, when we get to contracts, when we get to corporate formation and business organizations, bankruptcy, we're going to talk about crimes and we're going to talk about torts. So today what I want to do is just give you a basic overview of the differences between those two things, what they are, and then give you some examples. So Chapter 7 in your book goes through a very extensive list of crimes that apply to white-collar cases. We consider white-collar crimes those that apply to financial situations, situations involving securities, and typically situations involving businesses or business people related to the business that they're engaged in. So when we look at criminal law, the penal code in each state is different. Moreover, we also have state crime laws and we have federal crime laws. So when you think about what a crime is, you may say to yourself, well, that's an easy enough definition. I know what a crime is. But the reality is that even though you may commit a battery against me, the crime recognizes that while I am the victim of that action, the actual party and involved victim in that case will be the state or the government, because we recognize that crimes are prohibited actions against and punished by the government. Our criminal law developed over a period of time from common law all the way back to the English monarchy and developed into statutory law. So if you walk into a law library, there will be a penal code section that includes all of the crimes, not all of them actually, but most of the crimes that are prohibited in that jurisdiction, be it the state, be it the federal government. Misdemeanor crimes, so you're driving under the influence, your petty theft, those are all deemed to be misdemeanors in the state of California because you can serve less than 1 year in the county jail as a punishment for them. If you are subject to punishment over 1 year, then that is a felony charge in the state of California. When we break down a criminal statute, a crime must have at least 2 elements to it in order for it to be a crime. And when I say elements, what that is there are certain things that I have to prove to a jury or to a judge to show that you committed a crime. So the first thing that I have to show is that you acted with the requisite intent under the statute. So that is what you may have heard people call mens rea. That's your mental state or the intent during the time that you committed the crime. There are some crimes that are general intent crimes. And what that means is that you don't, in any scenario, have to intend to break the law. But a general intent crime requires that you commit a volitional act. So let's say I'm driving my car and I see a person that I really dislike. And I am driving and I decide that I'm going to turn the wheel and hit that person with my car. It's called an assault with a deadly weapon. I don't actually hit that person, but by turning my wheel, I know and have the mental state that if I turn the wheel, I am likely to cause great bodily injury or death to the person that I'm trying to hit. I'm acting with general intent. Spin that, and let's say I do hit that person, and I kill that person. I acted with specific intent because I wanted to harm and kill that person. So general intent just means that I have to commit a volitional act, whereas specific intent, there is an additional intent requirement. I either have to do it with malice, I have to do, which would be hate, right? Hate in your heart, or thinking with depraved thoughts, right? So that's the difference between a general and specific intent crime. You always have to have a mental state in order to have a crime occurred. If you are voluntarily intoxicated and you don't know that you did a crime, that could be a defense. If someone roofies you and you commit a crime, that may not be a crime because you're not acting with the mental state or intent required under the law. So the second element that we have to show in order to prove that a crime happened is that there was some act or a failure to act, an omission, and that is called the actus reus. As I mentioned, for the mental state piece, you have to commit a volitional act. You have to do something voluntarily. It's not that I'm driving along and my passenger takes the steering wheel out of my hands and rips it out and turns the car that I'm driving into that person. In that instance, I don't commit an act. I don't omit or fail to act. It's another person doing the acting on my behalf. So I could not be penalized or punished for anything that happens to that person. You have to commit an act in order for there to be a crime. Now, you all may have read ahead and say, hey, Cassandra, what about conspiracy? I'm going to get there in a moment. At its most basic, though, one thing for you guys to walk away from here is that ignorance of the law is never a defense. I don't have to know that it is illegal to try to run somebody over with my car in order to be held accountable for running somebody over with my car. When we talk about who can be responsible for criminal acts, you and I can be responsible for criminal acts all day long. But one of the things that we have recognized, particularly over the last 2 decades, related to a variety of financial downturns that our economy has taken, is that we have to hold corporations liable for criminal acts when they commit them, be it a la Enron and shredding all of the tax documents, be it PG&E for being negligent in their maintenance of their power lines and of their equipment. Those folks who work for corporations, act as corporate agents, act as officers, get to be held liable when they fail to act in a way that they should, that is prescribed by law, or when they do an act knowing that it could harm someone else or someone else's property. So California, talked about this a little bit, but it's a special flower. We like to hold corporations to a higher standard than potentially every other state. And one thing for you to take into consideration is that at the federal level, for example, after the 2008 recession, the Democratic Senate and House pushed really hard for there to be federal laws that target officer and director criminal responsibility for engaging in acts that they know to be inherently risky, both to their corporation, to their investors, and to the financial market at large, to dissuade people from acting in a similar way, right? So a great example is when we think about and when we talk about securities. So one thing that happened during the 2008 recession, well, as a predicate to the 2008 recession, was that they were selling mortgage-backed securities based on really risky mortgages. They knew that it was a huge risk. They knew that there was the potential for there to be disaster. And when that disaster came to being, Congress looked at the situation and said, we can't allow this to happen again. So they passed several laws, including the Dodd-Frank Act, and they added a bunch of laws to the Sarbanes-Oxley Act, all in an effort to criminalize and therefore penalize folks who engage in that kind of behavior. The Trump administration has rolled back a lot of those protections, for better or worse. And so you will see that criminal law and the law in general really flexes with the times. It is reactive, but it takes a really long time for the reactivity to actually take shape and to take hold, because the law is typically well behind our society at large. Now, I mentioned to you in distinguishing between misdemeanors and felonies that those are distinguished because of the amount of time you can spend in jail or in secured custody. But jail or secured custody time is not the only penalty that you can have for committing a crime. So you can be required to pay a fine, you can be required to pay restitution to any victims who you've harmed, you can be required to be on probation, you can be required to go to prison. Typically, our penalties for business or white-collar crimes will be a little bit different than the example that I gave you earlier of me running somebody over with my car. In business and white-collar crimes, there are some really neat penalties that can be assessed in ways that we don't assess them in blue-collar crime. So when we look at white-collar crime, some of the neat ones can be banishment. So I don't know if any of you have watched the Fire Festival documentaries that are on Hulu or on Netflix, but one of the things that happened as a result of that and the investigation by the Securities and Exchange Commission is that those folks that were heading that organization, the fire organization, some of them were banished and prevented from ever operating as an officer or a director for another company that's publicly traded or is involved in securities exchange. And so that's one of the types of penalties that you get in a white-collar crime that you don't get for a blue-collar crime, because unfortunately, from my perspective, there are folks who continue to commit crimes. They perpetrate the same crime over and over here in Tuolumne County and in other jurisdictions, and we don't get to banish them. We don't get to make them leave. We don't get to deny them being in our presence. And so that's a difference for white-collar crime. Now, as I mentioned, I think in one of our prior lectures, when I appear as a prosecutor, I don't appear for Jane Doe. I am appearing for the state of California. So when somebody is placed on probation or is sentenced to some sort of secured custody time, any fines or fees that they pay as a result of that grant of probation or going to jail, those penalties are actually paid to the government. And then those fines, particularly in the state of California, are given to the Victims of Crime Fund. And what that does is those fines are then used to support victims in ways that are financial, right? So sometimes we have folks who have to flee. Sometimes we have folks who lose homes, who lose time at work, who lose vehicles, objects are damaged. And so those fines and fees go towards helping to make those victims whole. Moreover, defendants can be ordered to pay what's called restitution. So basically, restitution, conceptually, is to place the victim where they were had the crime never occurred, right? Our whole job is to make them whole when we talk about paying restitution. So that can also be a penalty that is imposed in criminal cases. You will see on the screen that there are a whole slew of white-collar crimes listed here. I think that there are 16. Your book does an excellent job of summarizing these for you, so I'm not going to go into too much detail. Take note of conspiracies, okay? Conspiracy doesn't require that the crime actually occurred. Conspiracy penalizes and punishes the planning of a crime between more than two people, or between two people or more. Because we recognize that people committing crimes is really dangerous, but people agreeing to and planning to commit crimes is also really dangerous. So go ahead and take a look through all of those definitions in your book. I'm not going to spend a whole lot of time going through them. Some things for you to understand. I think I've already mentioned the difference between common law and statutory law. But basically what happened, particularly for criminal law and penal code statutory law, is we had this understanding and development of common law, right? Like things like larceny, the taking of another person's property, robbery, taking of property from somebody by force, burglary, breaking into and entering into the dwelling or building of another with the intent to commit a theft or a felony therein. Malicious burning is arson. So all of those were crimes before we wrote them down. And so basically what we did was we took those common law, criminal law understandings and we converted them into statutory penal code violations. So when I described for you the concept of Citizens United, how businesses and corporations are people too. So they have some constitutional rights, particularly when it comes to criminal investigations. Described for you already that those procedures, those rights don't really apply when we're talking about an administrative agency investigation. But if we're talking about a criminal investigation, there are Fourth Amendment rights for businesses, so they have to have warrants. There are some exceptions to that warrant requirement, which we've already talked about sort of ad nauseum when we talked about the loopholes that the Fourth Amendment has been broken up into. But emergencies, stuff in plain view, business records that can be subpoenaed. Some documents and records could be privileged, either because they're communications between the business and their lawyers or some other privileged relationship. But generally speaking, the Fourth Amendment also applies to businesses. The Fifth Amendment, however, does not apply to businesses because it only applies to people, right? So only a person can self-incriminate. Therefore, the Fifth Amendment does not apply. However, if police officers have somebody in a custodial situation, which typically requires some circumstance similar to arrest, not detention, but arrest, and they are asking them questions seeking to elicit a guilty response or interrogating them, then those individuals have the right to claim the Fifth Amendment and to not speak or incriminate themselves, but that only applies to self-incrimination and not incrimination of others or the business. But typically, it's not going to get broken down that far, and so if somebody invokes, these are their Miranda rights, cops aren't going to talk to them anymore. And if they do and get a statement that's incriminating in violation of the Miranda warnings, that statement will be excluded. Businesses are entitled to due process of law. Okay, so the Sixth Amendment, businesses have the right to a speedy trial, same as regular old folk do. You have the right to due process, so the right to be heard, the right to question witnesses, the right to present evidence on your own behalf, the right to utilize the court to subpoena or force people to come in to testify on your behalf if they have something that could provide exculpatory evidence or evidence that shows that you're not guilty. So that's a down quick and dirty on crimes. Your book, as I mentioned, goes into great detail about each of those crimes, so go ahead and read those. And if you guys have any questions, bring them to our lab. So our next chapter is chapter 8, and that's getting into tort law. So what is a tort? It's a delicious dessert, typically, but when we're talking about a tort in terms of the law, a tort is a civil wrong that interferes with someone's person or property. So when you distinguish between a tort and a crime, what you have to understand is that a crime arises from a violation of a public duty. We all have a public duty to not violate the law. However, a tort is a wrong that arises from the violation of a private duty, something that you have with another person that they may not share with the public. The same act can be a crime and a tort but not all torts are crimes. So a breach of contract is a tort because you, through your contractual relationship, owed each other a private duty to perform, but the simple fact that you violate a contract and you breach a contract does not necessarily mean that you have committed a crime. There are a variety of different types of torts, so I'm going to talk about them briefly. There are intentional torts. There is the tort of negligence, which is kind of a catch-all, so we'll talk about that. And then there's strict liability torts. And strict liability torts really applies to situations where there is something so inherently dangerous happening that because of that inherent dangerousness, regardless of how well or how poorly you perform that act, you're going to be held liable if something goes wrong because it is just that dangerous and you're assuming the risk associated with that act. But we'll talk more about that in detail in a minute. Now, intentional torts. It's kind of exactly what you would think when you utilize the word intentional. It's going to be that volitional act. So, an assault, which most people get confused with a battery, an assault is, for example, a swing and a miss. So I am threatening a person with imminent harm but not exactly causing harm, okay? Versus a battery, which is the harmful touching of another without their consent. Now, break that down into a variety of elements. So the act, right, is the touching, and it's on a person of another, and that person can't consent to it. One might argue that boxing, right, is just a whole series of batteries going back and forth, mutual combat. The reason that's not a tort, the reason why boxers don't sue each other is because they're there volitionally and they're getting hit with their consent, right? And then there's the intentional tort of false imprisonment. So this is detaining somebody without their consent. The one that I like to think about the most when it comes to false imprisonment in the civil aspect is the shopkeeper's privilege. So I don't know if any of you all have spent any time at the grocery outlet in downtown Sonora, but the owner there is Arthur Schmidt. He is fabulous. He will chase you down if you steal something from his store, and he will escort you back and wait for law enforcement to come pick you up. He will do it every time. He will find you. That is not the place for you to shoplift in Tuolumne County. Allow me to assure you of that. But he utilizes the shopkeeper's privilege to detain somebody for shoplifting for a reasonable amount of time to allow for law enforcement to respond. Many retailers no longer invoke the shopkeeper's privilege. A lot of places, larger places, TJ Maxx, Ross, they advise their employees to not contact shoplifters, and they in fact build in a percentage of loss every year across their entire corporation to cover the loss that they sustain from shoplifters. For better, for worse, it's a liability saver. They get to do what they do. Now, some lesser known intentional torts. You can have the intentional infliction of emotional distress, and that requires outrageous conduct that produces mental anguish in the person that's harmed. This could be something as simple as harassing phone calls over and over and over again. Statements that you make during those phone calls over and over and over again, okay? It's a good example of intentional infliction. There can also be invasion of privacy. So you don't get to publicly disclose private facts, okay? You don't get to intrude on somebody else's private affairs, and you don't get to appropriate another person's name, likeness, or image if you're going to utilize it for a commercial advantage. So one thing that I've been following, and I don't know if any of you have, is in the Kanye West, for some ungodly reason, presidential campaign, he featured Kirsten Dunst on one of his campaign posters. And she has sent him a cease and desist letter telling him to stop utilizing her name and likeness because she does not support what he's about. And so he could potentially be sued for invasion of privacy as an intentional tort because he used her likeness and her name and her image without her consent. A good one for you to think about in terms of intentional torts is going to be defamation. So And I'm sure you've probably heard people sling that word around, right? That's defamatory. Don't you defame me. Okay. So defamation necessarily requires a false statement. So a defense to defamation is the truth. So if somebody says something nasty about you, but it's the truth, then you don't get to claim that they defamed you. So if I were to defame somebody using spoken words, that is slander. So a good way for you to think about spoken defamation is that it's slander, right? They both start with an S. And then if I were to write something that's false about somebody else, then it's called libel. So one area where defamation law has really equal parts stagnated and exploded has been online, right? So when you think about what people can say about other people on social media, it is crazy, right? And this goes farther than just, regular old defamation, because defamation has also applied in those cases where people commit suicide from online bullying. It's a huge issue right now. And so the courts are really struggling with what defamation is in those scenarios. And as I mentioned, the truth is a defense to defamation. So you may not have committed the crime of defamation if something is true. Or if what you were told and the relationship that you had with the person that you told it about, if that's a privileged relationship, then it's a defense to defamation. Some other kind of business law focused intentional tort. So you can have product disparagement, right? Again, has to be false. Wrongful interference with contracts. So if there's a third party who's trying to interfere with the conduct required in a contract, or trying to steal away folks who are already engaged in contracts for the same purpose, that's an intentional tort. And then, of course, trespass, which is the unauthorized action being on somebody's property, be it land or personal property, without their consent. Now, negligence is a word that I think gets thrown around a lot. And so much like in criminal law, negligence also requires a series of elements be proven prior to the court finding that a party was negligent. And so first, there must be a duty to exercise reasonable care in the situation that you are claiming negligence occurred. There then must be a breach of that duty. That breach must have been the cause or must be connected in some way to the injury that was suffered. And then there, in fact, does have to be injury. There has to be an actual loss sustained in order for a cause of action of negligence to be proven. Now, there are a series of defenses to negligence, and this is one of the areas that you should pay attention to, because there are a variety of defenses that you can invoke if somebody says that you, perhaps as a business owner, were negligent and that they were injured as a result of your negligence. So, in some states, there is a complete bar to recovery. You don't get anything if you're injured if you contributed at all to your own injury. So in a contributory negligence jurisdiction, the plaintiff's negligence can be a complete bar to their recovery. If you are 1% negligent in a contributory negligence state, you get nothing. Contrast that with a comparative negligence state, where the plaintiff or the person who says they are harmed can contribute to their own negligence and still recover for the portion that they were not responsible. So let's say you were 51% responsible for an accident in the state of California, or in a state that utilizes a pure comparative negligence state. You would be entitled to 49% of your damages from the other party because they were 49% negligent. Now, in some states, there is no recovery if your negligence exceeds 50%. So California is one of those hybrid states. If you are more than 51% negligent for your own injuries, you don't get anything. But if you're anywhere below 49.9999999%, responsible for your own actions, for your own injuries, you get to recover the remaining balance from the other party. Some defenses to negligence that have been eliminated, and they were eliminated for public policy purposes. So California has eliminated the assumption of the risk defense. But it's an interesting one to talk about, particularly in a county and in an area of California where lots of people engage in outdoor recreation activities. Oftentimes, when you go get a lift ticket to go skiing or snowboarding, for all you folks that are winter sport people, when you sign for your lift ticket, are basically agreeing to indemnify the ski resort that you're skiing at so that they're not held liable for anything that happens to you while you're skiing or snowboarding there. That is called an express assumption of the risk. You are recognizing by written acknowledgement that there is a risk involved in the activity that you are going to engage in and that you are releasing them from any liability. Now, in California, those are not enforceable. So they can have you sign it all you like, but we have eliminated that as a defense because we recognize as a public policy issue that we don't want people to just be able to be absolved from their own negligence. Because let's say you go to a ski resort, every single person that gets on that mountain has to sign one of those. What is the incentive that the resort has to take care of you and to take care of the lifts and to take care of the mountain and to make sure that everybody's safe? None, right? Because everybody signed away their liability. And so recognizing that, we have eliminated that as a complete defense. Another great example of this is, I don't know if any of you are skydivers. That seems to be a pretty consistent theme in some of my classes. I don't know why, but I always have a skydiver or two. I think we can all agree that jumping out of an airplane while it's in the air, hoping that a parachute catches me and levitates me to the ground without harming me, is an inherently dangerous activity that you engage in, right? But people do it every day. And so when you think about that inherently dangerous activity, let's all be really, really happy that we don't have the assumption of the risk defense in California, because all of those poor folks who have perished at that Lodi skydiving school would get nothing because it's an inherently dangerous risk. And that just isn't fair. And it's not good because then that gives that business no incentive to do things the right way. Now, governments are typically going to be immune from tort liability. The federal government has passed the National Tort Claims Act that prohibits you from receiving any sort of recovery from government agents that commit torts, government agencies that commit torts. There are exceptions to those rules, but they're pretty complicated, and so just typically, governments are usually immune from that liability. Strict liability. So I explained this a little bit earlier, but strict liability torts are absolute standards, right? So we recognize that there are just some situations that are so dangerous. They are so dangerous that they require that if something goes wrong, someone's going to be held accountable. Why? It's so those people have an incentive to do it right and to do it right every single time, okay? Great situation for you to think about when we think about strict liability is the use of explosives, demolition, mining using explosives. We know that explosives are inherently dangerous, and we know that sometimes you can't predict what they're going to do, right? Things can go wrong a whole bunch of different ways when you're using explosives. And so because of that, whenever you utilize explosives to do anything, if something goes wrong, if a building falls the wrong way, if windows, that were supposed to be removed blow out instead and cause damage to a neighboring building or a person down below or vehicles, you're going to be held liable. Now, Another place where strict liability is most common, particularly in white-collar situations, is going to be product liability. So everybody thinks about the McDonald's, hey, caution, coffee's hot situation, right? And so that actually developed out of a negligence case. But when we think about strict liability, again, it has to be a situation that is so dangerous that we recognize that inherent dangerousness and everybody has to be behaving in their best way. Another way that strict liability can happen, in a good example, dangerous dogs. So if your animal has a history of biting other people, biting other dogs, the government has created a mechanism by which the government can recognize that that is a declared dangerous animal. And if it subsequently harms someone else or something else, strict liability will be imposed and you're going to be on the hook for that regardless of why it happened. Because again, you now are on notice that that animal is inherently dangerous. Now that doesn't apply just by breed, because I've known some pretty vicious dogs that have no level of any kind of specific breed in them, right? It's not breed specific. What it is animal specific. Okay, so that is a quick summary of chapters 7 and 8. Make sure you do your reading, and I will see you guys in our next recording. Bye.